This episode of Legaleagle was made possible by Skillshare. Learn to think like a lawyer for free for 2 months by clicking on the link in the description. Recent events have raised the question of whether a sitting president can be indicted while in office, or whether the president is immune from criminal prosecution. It has never happened before. The text of the Constitution is unclear, and there are good arguments on both sides. Welcome to Lawsplainer, a new series on Legaleagle, where I try to tackle some of the core legal concepts that form the foundation of our society, because sometimes the law is complicated and needs to be explained. Today we are talking about whether a sitting president can be criminally indicted. This is a legal concept that becomes relevant every 20 years or so, starting with President Nixon, moving on to President Clinton, and now potentially President Trump. But first, let's talk about the difference between indictment and impeachment. Indictment is a criminal accusation against an individual. It is essentially the way you start a criminal prosecution. So, for example, if someone murdered another person, the state would indict that person for murder. However, impeachment is a purely political mechanism used to remove an official from the federal government. It is a formal charge of wrongdoing and potentially removing them from office, but unlike an indictment, it does not necessarily result in jail time. In popular parlance, impeachment generally refers to the president, but it can actually refer to a wide variety of federal government employees. In fact, most of the impeachments that have actually occurred involve Supreme Court justices, not just the President of the United States. So you might ask, why would anyone think that the president is immune from prosecution? Well, first let's recognize that most government officials are immune from suit in order to allow them to focus on their jobs as elected officials. For example, the doctrine of qualified immunity protects officials from facing criminal charges or lawsuits for their actions as long as their actions are within the course and scope of their jobs. Qualified immunity is often a defense that gets raised in suits against police officers or police departments. Additionally, looking at the text of the Constitution, you'll notice that it does mention impeachment of the president, but it does not mention indictment. However, the absence of that statement does not necessarily mean that it's not available, so there's ambiguity in the Constitution, which is why the Office of Legal Counsel has dealt with this topic on a few different occasions. The Office of Legal Counsel, or OLC, is part of the United States Justice Department that acts as a legal advisor to the president and the executive branch when they have questions about the legality of a particular action or law. Generally, it's seen as a non-partisan office. When the president has a question of law, he or she turns to the OLC to give an objective opinion. Relevant here, the OLC has written 3 memos on the question of whether the president can be criminally indicted. The first OLC memo was issued in 1973, shortly before the Saturday Night Massacre, in which Nixon fired Watergate Special Prosecutor Archibald Cox, and the top 2 justice officials resigned in protest. That memo considers the Constitution's text and finds no answer. It finds that the Constitution provides very limited immunities for members of Congress and none for the president. With no clear constitutional answer, the OLC lawyers asked what answer would best serve the nation. They found that an indictment in office would besmirch the, quote, symbolic head of the nation. And given that impeachment is the only tool mentioned in the Constitution, the memo finds that this would suggest strongly that criminal proceedings against a president in office should not go beyond a point that would effectively remove the president and thus become a shortcut to impeachment. A second memo written just a few days later by Robert Bork argues that the same points apply to the vice president as well. Of course, those memos were never tested, as President Nixon resigned before either impeachment or indictment and was pardoned by President Ford. 27 years later, in the year 2000, the OLC re-examined the question. By this time, there had been major Supreme Court decisions, which we'll talk about in a second, all indicating that the president was in fact not immune to the reach of the justice system. But the OLC found that despite case law, the president was still immune from criminal prosecution. The OLC memo from the year 2000 states that, quote, the framers considered who should possess the extraordinary power of deciding whether to initiate proceeding that could remove the president, and place that responsibility in the elected officials of Congress. It would be inconsistent with that carefully considered judgment to permit an unelected grand jury and prosecutor to effectively remove a president by bringing criminal charges against him while he remains in office. So again, the OLC concluded that a sitting president could not be criminally indicted. However, unbeknownst to the public, 2 years earlier in 1998, A secret memo written for independent counsel Kenneth Starr reached the opposite conclusion. At the height of the Starr investigation and the Lewinsky scandal, independent counsel Kenneth Starr commissioned a legal memo seeking guidance on this question as to whether a sitting president can be indicted. Mr. Starr assigned Ronald Rotunda, a prominent conservative professor of constitutional law, to write this memo as a consultant. The memo has only recently been revealed after a FOIA request by the New York Times. The Starr memo argues that President Clinton at the time could be indicted because, quote, the U.S. Supreme Court has repeatedly reaffirmed the statement that no one is above the law. The memo argued that the independent counsel statute itself made no sense if the counsel could not in fact indict the president, and President Clinton had consented to passage of the statute that created the office, so in effect he had consented to being indicted. The Starr memo argued that it is, quote, proper and constitutional and legal for a federal grand jury to indict a sitting president for serious criminal acts that are not part of and are contrary to the president's official duties. The Starr office memo concludes by saying that in this country, no one, even President Clinton, is above the law. So in terms of executive branch memoranda, there have been 3 memoranda that say that the president cannot be criminally indicted, at least not while in office, and one that says the president can in fact be indicted while sitting as the president. But you should probably consider the bias of these particular sources. The 3 no indictment opinions were issued by executive branch lawyers who in fact work for the president. And the one legal memorandum that argues that the president can be indicted came specifically at the request of the famously, perhaps infamously zealous Kenneth Starr. Of course, it has been noted that the Department of Justice has an active policy of not indicting a sitting president. However, this is a policy preference of the Department of Justice, and no one argues that it is mandated by the Constitution or statute. It may or may not be a good idea, but there is no law that requires this particular DOJ policy. And this DOJ policy and those memos from the Office of Legal Counsel may be well-reasoned, but none of them are binding. The final answer may come to us specifically from the Supreme Court of the United States. And if we're talking about the Supreme Court, we should look at past Supreme Court precedent. There are 2 Supreme Court cases that are on point. The first is U.S. versus Nixon. In that case, Nixon argued that he need not turn over what became the famous Nixon tapes, the smoking gun of the whole Watergate affair. In U.S. versus Nixon, the Supreme Court confirmed that the president is susceptible to discovery that might result in criminal charges against the executive. The Supreme Court rejected President Nixon's claim to a, quote, absolute unqualified presidential privilege of immunity from judicial process under all circumstances. U.S. versus Nixon required that the president turn over his tapes to a court seeking to use them in a criminal case against other defendants. This was a unanimous decision of 8-0, with Justice Rehnquist recusing himself because of his close ties to the Nixon administration. The next relevant Supreme Court case came about 20 years later in Clinton versus Jones. In 1994, Paula Jones filed a civil sexual harassment suit against President Clinton. Although the allegations related to Clinton's conduct as governor of Arkansas, Jones filed her suit about 5 months after Clinton took office as president. Although Clinton, like Nixon, claimed absolute immunity from legal process while in office, the court again rejected that claim. The Supreme Court held unanimously that President Bill Clinton could be sued in civil court over the sexual advances he allegedly made while being governor of Arkansas. Clinton's lawyers, like Nixon's before him, argued that the president's participation in a trial would imperil the executive branch because it would distract him from all the complex and numerous responsibilities of being president. But the court decided that this principle was outweighed by the requirement that litigants be able to seek justice when they are wrong. Although Clinton v. Jones involved a civil case and not a criminal case, there's probably no reason why the court's logic can't extend to criminal cases. Indeed, you could argue that the interests of justice would be even more important in a criminal case as opposed to a civil case for damages. Like many issues in constitutional jurisprudence, there are no easy answers to this particular question. And when lawyers don't have binding precedent, they make what are called policy arguments. In other words, in cases of first impression, they argue what would make the best law. So let's look at a few of those arguments on both sides. Those arguing for immunity from indictment would claim that the president is singularly important. They would argue that the president can't be distracted by civil and criminal suits that would prevent the president from turning his or her attention to actually running the country. And in fact, this was the basis of Justice Kavanaugh's law review piece that became relevant during his confirmation hearings. Kavanaugh argued that because the president is so important, Congress should pass a law that makes the president exempt from investigations, exactly the kind of investigations that Kavanaugh helped run during the Starr investigation. However, Kavanaugh doesn't argue that this is mandated by the Constitution, simply that Congress should in fact pass that law. Proponents of immunity would also argue logistical problems. The president is the head of the executive. So how can the president effectively oversee his or her own trial and investigation and potential criminal conviction? They would also argue that we already have a remedy, impeachment. If the president has done some sort of wrongdoing, it's up to Congress in order to reprimand the president and remove them from office. And once they are removed from office, then prosecute any crimes that may or may not have occurred. But I think even those that would argue for immunity would agree that if indeed the president is immune from criminal prosecution of events that occurred before they became president, that the statute of limitations must be told while they're in office. Otherwise, becoming president literally would be a get-out-of-jail-free card. On the other hand, those who would argue against presidential immunity and those who would argue that in fact a president can be indicted would point out that pre-election conduct is by definition not related to their job as president. No official should be above the law. It's a principle that is reaffirmed time and time again from the Supreme Court. And to borrow an example that President Trump uses from time to time,
I have the most loyal people. Did you ever see that? Where I could stand in the middle of Fifth Avenue and shoot somebody and I wouldn't lose any voters, okay? It's like incredible.
If he shot a man in cold blood on Fifth Avenue, perhaps his followers might not care, but I think as a society we would probably want the president prosecuted for that crime. This issue is sort of like the Schrodinger's cat of politics. As with many things in the law, we may not have an answer until the actual action in question is taken, and the Supreme Court issues a decision that finally tells us one way or the other. Until then, in the absence of a law passed by Congress or a constitutional amendment, we may never know the answer to this question. But if we do ever have a sitting president that is indicted and criminally convicted, they can make good use of their jail time by taking a course on Skillshare. Just spitballing here, but they could take Matt Cooper's class on accounting fundamentals, so they don't have any issues with their tax returns. Or they could take Guy Kawasaki's class on turning ideas into high-growth businesses, so they can learn how to run a profitable business that never has to file for bankruptcy. Skillshare is an online learning community that has over 20,000 classes on everything, like business, design, and technology. The first 500 Legal Eagles to click the link below will get 2 free months of Skillshare. The free premium membership gives you unlimited access to must-know topics so you can improve your skills and learn new things. Learn something useful, not politics. Click the link and get 2 free months and start learning today. And until next time, I'll see you in court.